Hello everybody, I'm George from Ireland, so welcome back to the English Law Channel. So carrying on with tort and looking at, by the way, that there's no liability for an omission to act. So you might have a moral obligation to help people out of a perilous situation, but generally speaking there's no legal obligation. Stoven and Wise 1996 was a case about this before the appeal court in failing to act. On a road verge there was an earthen bank which was blocking the driver's view and had led to a number of accidents. So Norfolk County Council was cognizant of this issue, they'd been informed of it, and they had the legal authority pursuant to the Highways Act of 1980 to improve the road junction, to dig out the bank of earth which was blocking visibility. But they decided that they would, a decision to remove the hazard was taken, but the authority didn't actually use their statutory power, which was to demand that the landowner remove the earthen bank. So Mr. Wise negligently drove out from the side road, not having stopped to look properly, and he claimed that the earthen bank made a serious contribution towards the accident that followed. It was not just his negligence. So the applicability of the principle was found here, but generally speaking, you're not an omission doesn't give rise to tortious liability, because the defendant hadn't created the harm, the county council. So the House of Lords, by a narrow majority, found the local authority did not owe a duty of care to motorists for failing to use their legal powers to remove the earthen bank. Lord Hoffman said there were political, moral, economic reasons for their ruling. This is what he said. There are sound reasons why omissions require different treatment from positive conduct. It is one thing for the law to say that a person who undertakes some activity shall take reasonable care not to cause damage to others. It is another for the law to require that a person who is doing nothing in particular shall take steps to prevent another from suffering harm by the acts of third parties like Mrs. Wise on natural causes. Close quotations. So Mrs. Wise is the person who was injured by Mr. Stoven. So I'll move on. So Lord Nichols expressed the majority view. He was the one who voted no, Norfolk County Council should be held liable. And he said, yeah, usually there should be no imposition of liability for omissions. However, he felt an exception should be made in this particular instance. And he said it could be tricky about whether something goes into the omissions category or not, but that there should be a presumption of care in duty of care in certain cases. He said, the recognised legal position is that a bystander does not owe a duty to a drowning child or a heedless pedestrian to take duty to take steps to save him. Something more is required than being a bystander. There must be some additional reason why it's fair and reasonable that one person be regarded as a brother's keeper and of legal obligations. When this additional reason exists, it's said there's sufficient proximity. That is the customary label. Close quotation. So Lord Nichols was saying that Norfolk County Council's position was not analogous to a bystander. It had legal authority to sort out roads, and it wasn't using that authority when it was supposed to. Anyway, he was the majority, so his view did not prevail. This omissions principle has been confirmed yet again by the Supreme Court in Robinson against Chief Constable of West Yorkshire Police in 2018. This is what Lord Reed had to say in that case. The distinction between careless acts causing injury, for which the law generally imposes liability, and careless omissions to prevent acts by other agencies causing personal injury, for which the common law generally imposes no liability, is not a mere alternative to policy-based reasoning, but is inherent in the nature of tort of negligence. Close quotation. The court was also saying this would just open the floodgates and there'd be too much liability, and political and economic decisions had to be made, and public authorities, they can't sort out everything. So the court was very reluctant to burden them with something. There isn't enough money, there aren't enough resources, there isn't enough time to take preventive action everywhere. So when does the law impose a liability for omission to act? Because there are a number of clearly defined relationships in cases where it does. So where are the exceptions to this broader exclusionary principle on liability for omission to act? So the duty to take positive action is there if there is a special relationship or relation of power and control between the parties. And in deciding in which situations a general rule should be departed from, a number of questions have to be asked. Has the defendant entered into a relationship with the plaintiff, which the law attaches positive duties to ensure that harm does not come to the claimant? There are instances of such duties, for example, a parent to a daughter or son, or the occupier of a premises to a lawful visitor, an employee to his or her staff in the workplace. There's the Ogapogo 1971. This is a Canadian case where a defendant invited someone onto his yacht, and then the claimant accidentally fell overboard. So did the relationship between host and visitant mean that there was a duty to assist someone who'd fallen off the yacht? And they said, yes, the defendant is not simply someone who happens to be a passerby. He has a duty to try to save the person. Okay, another question to ask is, has the defendant assumed responsibility for the well-being of the claimant in some wise? Phelps against Hillington London Borough Council. The House of Lords said an educational psychologist who was hired by the Borough Council was under a duty to help Miss Phelps and had not diagnosed her dyslexia. The decision was on the ground that the educational psychologist was hired precisely to diagnose dyslexia if it existed, and therefore make decisions about educational provision for the child. And it was patent that parents and teachers would be likely to follow that guidance. Educational psychologists therefore assume a duty of care to their pupils. Otherwise, why else do we hire them? They're supposed to be their field of expertise. Otherwise, they've got no responsibility at all. They're useless. So Lord Slynn said the phrase can be misleading. It can suggest the professional person must knowingly and deliberately accept responsibility. The phrase means simply the law recognises that there is a duty of care. It's not so much as responsibility is assumed as it's recognised and imposed by law. Close quotation. That the educational psychologist hasn't actually signed a document saying, yes, I take responsibility, I assume liability, but nevertheless they have that liability. They've got to do their job properly. That's precisely what they're paid for. There's another instance of this assumption of duty of care in Barrett against Ministry of Defence 1995. So there was a relation and proximity between the defendant's behaviour and the claimant's harm, which meant there was an assumption of responsibility for the claimant's welfare. There was a culture of heavy alcohol consumption at a naval base, and where the drinks were tax-free. And so one evening after a debauch, a soldier, he fell into a stupor, and whilst he's in a crapulous state, when he was not compos mentis, probably unconscious, the duty officer said, okay, we'll just take him to that room and he can just sleep it off there. Anyway, the man vomited in his sleep and suffocated as a result. So the man's widow, she brought an action of negligence against the Ministry of Defence because she said that the military officer had assumed responsibility for this man and therefore was duty bound to check on him periodically, and hadn't checked on him whatsoever. Had they checked on him even once, that might have been sufficient to save him. The Royal Navy was not found to be liable for preventing the dead man from drinking too much. He was an adult, yes, he can get himself inebriated, anything that happened before his collapse. But once they'd taken him to his room, then they had assumed responsibility. They recognised there was a perilous situation. There's Sudradar against NERC. The House of Lords all agreed that the defendant was not liable for something which he did not do. There was no relationship or proximity in that case between the claimants and the defendant. This is about testing water in Bangladesh. They were not supposed to test for arsenic in water. They had a different duty. That's not their problem. And the third question to ask is, has the defendant been put into a position of danger or risk that they failed to address? A defendant could be liable to reduce this danger or to avoid it altogether when they're aware of it, even if they're not the ones who actually caused it. In Goldman and Hargreave, 1967, the appellate court held a case of the defendant's red gum tree, which is over 30 metres high. It was hit by lightning and caught fire. The defendant caused the land around it, the burning tree, to be cleared, and the tree was then cut down. But he didn't put out the fire after he did this. He thought the fire would burn itself out, but it was still smouldering, and then the wind came along, a warm wind, and that reignited the fire, and it spread onto adjacent land. The defendant was negligent for not being sure to put the fire out altogether. They found there was foreseeability of this risk. So anyway, in this case, the defendant didn't have to show a duty of care of a reasonable person, but only what he was able to do, bearing in mind his state of health and the resources available to him. Okay, there's Capital and Counties PLC against Hampshire County Council. A fire officer went to a fire, and then he said that the sprinkler system must be switched off, which was done, which therefore hugely aggravated the damage arising from the conflagration, because the fire wasn't actually extinguished. So he wasn't liable for failing to extinguish the fire, but he was liable for his positive act, which was switching off the sprinkler when he should not have done so. Anyway, because that made the damage appreciably worse. Thanks for watching. Toodaloo.